Basically, what the state alleges happens in this case is Mr. Walker and his wife went to the courthouse. They tried to get in. Courthouse personnel asked Mr. Walker to identify himself. He wasn't happy about that. And Your Honor, I don't want to muddy the waters anymore, but I'm afraid I'm going to.
Continue to muddy, Mr. Page. Count 3, and the state has had multiple opportunities to clarify this point. Count 3, in the view of the court, does not properly charge battery on a law enforcement officer. It charges battery. I see your point, Mr. Pate. Your response, Ms. Gillette?
With all due respect to the court, I had a jury trial last week because I had jury trial set 2 weeks apart by the court on the master calendar. Therefore, I was in jury trial prep, and doing jury trial all last week. And I've had jury trials 2 weeks apart more than once this year, because I had other stuff that was also pressing that comes in while I'm in jury trial, such as child in need of care information, which has to be done in a very specific time limit as well. And seeing as how neither of my counties can afford to have extra assistants that can do all of this extra work, I do it myself.
State of Kansas versus Robert L. Walker Jr. South County case number 2023 CR 29. Jill Gillette appears as Elk County attorney. Robert Walker, the defendant, appears in the office of his attorney, Gary House. This matter comes before the court on a motion of Mr. House to withdraw as defendant's attorney. Mr. House, I've read your motion. It's well drafted. However, you've been with this defendant for 14 months now, and only now you find out that there are some conflicts that you now believe to be unable to be reconciled?
Your Honor, the matters concerning social media and so forth, I've talked with my clients about it, and as I indicated in the motion, they've indicated they had no direct involvement in that, but it has evolved to the place that I know it's created a big distraction at the courthouse, and then Robert and I think we've probably gone different ways on how his case ought to be defended. I was more concerned about the felony charge, which, if convicted, carried possible penitentiary time. And Robert is concerned about First and Fourth Amendment rights and the fact that he probably shouldn't have been arrested in the first place. And so we're going down different roads there. And then, as I indicated, also I've got some medical issues right now that make it hard for me to, try a case that's going to last multiple days. So that particularly was the reason for that. In conversation early last week, I just asked Robert, "Are you dissatisfied with my services?" And he said, "Well, yeah, yes, I am. I don't think things have been moving fast enough, and there's things you haven't done, and there's motions that you need to file." And so that's the reason for moving at this late date. But I thought with the medical issues that might come up at the end of this next month, I needed to consider getting out of the case, and Robert agreed.
All right. Well, generally you're allowed to speak for your client, but in this situation, I'm going to address Mr. Walker personally. Both in his written motion and here orally, he's asserted that you support this withdrawal. Is that correct, Mr. Walker? Do you intend to retain counsel to take his place?
Do what?
Do you intend to hire counsel to take his place?
I don't have the means to hire an attorney. And he was appointed there. And I figured that I would be able to get another one appointed that would take up the case.
I certainly am somewhat sympathetic to Mr. House's situation. I'm going to go ahead and grant the motion for withdrawal this time and relieve Mr. House from further responsibility as Mr. Walker's court-appointed attorney. With that said, Mr. Walker, I have no intention of continuing this trial. This comes up about 5 weeks before your trial date. I don't want to continue this. It's already been continued once. I feel like that another delay in this case would compromise both parties. We need to get a final resolution of this matter. So this court will attempt to appoint a new lawyer who has the freedom to get up to speed and be ready to try this case in November. Ms. Gillette, while I don't really think that there's a whole lot for you as prosecuting attorney to address at this point, I do want to give you the opportunity to make whatever statements or requests that you need to make at this time.
Judge, I didn't have an objection to Mr. House withdrawing. He told me that he was going to, and he filed the motion. Same as you, I know Mr. House's candor. He was previously a judge that I practiced in front of, so I do know that he only withdraws when it's necessary. So I didn't have any objection to him withdrawing. Scheduling wise, we've got everyone subpoenaed, so we're ready to go. I'm just concerned about the amping up of actions by those parties that have continued to make efforts on our behalf of Mr. Walker, and including people following me up the stairs. I tried to stay calm and they yanked a door out of my hand, which actually could result in charges of battery of an LEO, because I am a law enforcement officer in my acting duties. So in addition to that, there's other issues that are going on with that stuff. So it's just amped up, and I'm worried about security, as I've expressed before. And we've talked about security with Mr. House and you and myself. And so I just still am very concerned about security for the trial.
I just hope Mr. Walker is in no way the catalyst for any of these activities.
I'm not.
Well, there continues to be things posted on his pages that he and his wife started as catalysts that make others in the community amp up, and it has continued on and on and on. They should have no contact with any of the witnesses in the case, and some of them are still within the courthouse and other offices. So it should be reiterated not to be intimidating or having any contact, even through the third parties that they brought in to help with their actions. Even a third party contact could constitute violation and intimidation of a witness.
So noted, Ms. Gillette. Mr. Walker, I would hope that you would do whatever you could within your power to settle things down, not ramp things up.
I haven't ramped anything up at all.
Well, immediately following the gag order being instituted, Mr. Walker posted a picture of a pig in a police uniform with statements about the court's gag order on his Facebook page that he created with his wife. He's made others also administrators of that page, but he made light of the court's gag order. And it's not something to be taken lightly. It's to preserve the integrity of the jury trial and everyone involved in it. And Mr. Walker himself made light of the court's gag order immediately after the case.
I said I couldn't talk about the case. I had a gag order on me. It all come out during the trial, all the evidence.
All right, I think perhaps there's some matters here that's beyond the scope of the hearing that was set this morning. Mr. Walker, you'll be notified in due course as to what attorney has been appointed. I hope that you cooperate fully with that new attorney and so that you can both be ready for trial on November the 6th when this case is set as prime.
Okay.
And then again, don't forget about that pretrial conference that you have the mandatory obligation to appear for Wednesday, October the 30th at 10 o'clock in the morning.
3 weeks later.
This is in the District Court of Elk County, Kansas. Case entitled State of Kansas versus Robert Walker. Case number 2023 CR 29. Jill Gillette appears as Elk County attorney. Chris Pate as defense counsel. Robert Walker appears in the office of his attorney, all by Zoom. This matter comes before the court at this time for a hearing on a motion which was filed by the defense in this case. Mr. Pate, please outline for the court what you are requesting this morning.
Your Honor, there's really two things in the motion that I'm requesting, and then after I get through with that, there's an additional issue, I think, in a prior motion filed by Mr. House that I want to confirm what happened. But as to my motion, the first part of it really deals with the count one of disorderly conduct. Ms. Gillette has Mr. Walker charged with disorderly conduct under 216203. However, she does not specify which subsection. There's 3 different alternative means by which a person can be charged with disorderly conduct. One of them is brawling or fighting, which I'm certain it's not that. The other is fighting words, and then there's engaging in noisy conduct tending to reasonably arouse alarm, anger, or resentment. So I'm not clear if it's the fighting word section or the 3rd section of the disorderly conduct statute. And the other thing that's not clear from the charging document, and I know the court hasn't had the benefit of sitting at the preliminary hearing or seeing the video or anything like that. Basically, what the state alleges happens in this case is Mr. Walker and his wife went to the courthouse. They tried to get in. They have the buzzer system out there. Courthouse personnel asked Mr. Walker to identify himself. He wasn't happy about that, and then he allegedly was causing a scene and yelling and things of that nature, and then allegedly went over to the sheriff's annex building and engaged in a discussion with the dispatcher, who I guess is also the person that handles the intercom system. Then Deputy Bliss got dispatched. She came up and talked to Mr. Walker. This is on the video. I've seen that. He obviously was not happy. She was trying to engage in a discussion, get him to identify himself. Didn't place him under arrest or anything like that. The discussion continued. Mr. Walker allegedly did not cooperate with her in giving the information, and then she made the decision to arrest him for disorderly conduct. So I think the state needs to, at a minimum, clarify the information, clarify what acts they are saying are criminal, and then specify what subsection of the statute they're charging Mr. Walker under so that I can adequately prepare for a defense. The second issue, and if I've missed it, I apologize because I'm pretty new to this case and I'm working on a short timeline. The state sent over discovery. The state sent over a video disc that has body cam from Deputy Bliss, from Deputy Watts, and then some video from inside the jail. But what I don't believe I have is the video from the courthouse. And in watching the body cam and in having been to Elk County a few times, I'm certain there are video cameras at every door to the courthouse. And I believe there's also video inside the sheriff's annex. So if there was disorderly or criminal behavior on the part of Mr. Walker at the courthouse door in the sheriff's department before Deputy Bliss came out, that should be on video. So if that video exists, I would ask that the state be ordered to turn that over as well to help prepare for the trial.
All right. Ms. Gillette, it would appear that a bill of particulars would clarify the issues that Mr. Pate raises regarding the subsection of the statute that you're invoking here to charge disorderly conduct and the specific acts which you're alleging constitute disorderly conduct. Do you disagree?
Judge, it says in the amended complaint filed August 15th, 2023, using fighting words or engaging in noisy conduct tending reasonably to arouse alarm or anger or resentment in others, to it, yelling, cursing, and making a scene, causing the courthouse doors not to be opened.
All right, Mr. Pate, your response to that?
Well, and again, I want to clarify, Ms. Gillette addressed a amended complaint from August 15th of 2023. There's a second amended complaint filed November 13th. So I guess I had presumed we were proceeding under the second amended complaint. I think the charging language in count one is the same, but can Ms. Gillette confirm which complaint we're proceeding to trial under?
It is both the same in count in the amended complaint and the second amended complaint. It was count 3 that was modified in the second amended complaint. So it's the same.
Well, and I mean, if Ms. Gillette is saying the disorderly conduct is what occurred at the courthouse doors and the courthouse doors only, then I mean, that's fair, but then I think the evidence presented at trial ought to be limited to that. And there's also the secondary issue.
It's the yelling, cursing, and making a scene that continues the entire time. He goes from the courthouse to the sheriff's annex, screaming and yelling and threatening the dispatcher, then back to the courthouse. So it's the entire pattern of events. He didn't just stay at the courthouse. He caused those doors not to be open because more than just the Deputy Bliss is the victim of the disorderly conduct. The entire courthouse was calling, begging him not to be let in. There are witnesses listed from the treasurer's office, the county clerk. There's all different kinds of offices that are involved, including one of the deputy court clerks that could hear him in the second story screaming and yelling outside the courthouse. So it's the series of events. It isn't just one specific location. He did it there in the courthouse and back. So it's the fact that he went over and threatened a dispatcher, came back to the courthouse. That's the scene he made outside the door, at dispatch, and then back is a series of events that leads up to his behaviors of not getting into the courthouse.
Well, and Your Honor, I wasn't finished before Ms. Gillette cut me off. So I guess if I could finish.
You certainly may, Mr. Pate.
Ms. Gillette raises even more issues. The making a scene causing the courthouse doors to not be open. That's what's alleged. My understanding, for one, is the courthouse doors weren't open because he refused to give his name. And then maybe there was a scene after that. But now we're talking about things that happened in the sheriff's office, things that happened with Deputy Bliss, which is outside the scope of what she just alleged. And the second issue, she's still charging different means of committing this within the same count. It's still charged as using fighting words, which is one means of committing disorderly conduct. The second means of committing disorderly conduct is the noisy conduct tending reasonably to arouse alarm, anger, or resentment. So we still haven't specified which manner of committing disorderly conduct the state is charging, and I think they need to specify which.
The state is allowed an alternate theory, Your Honor, and this allows both alternate theories to be given as jury instructions.
The court, having heard from both parties, will grant the motion for a bill of particulars, requiring the state to provide to the defense within 7 days of today's date, a bill of particulars setting forth the specific conduct alleged by this defendant to constitute disorderly conduct in relation to both alternative theories within the disorderly conduct statute. So, Ms. Gillette, to make sure that it's clear, you need to allege specific facts that would constitute violation under each specific subsection that you're alleging for disorderly conduct. And I will require, since we've got a trial date looming, that be provided to the defense within 7 days of today's date. Failure to do so will result in dismissal of that charge. All right. Having made a ruling in regards to that part of the motion, Ms. Gillette, let me ask, are there videos of the exterior outside the door of the Elk County Courthouse? And if so, why weren't those turned over to the defense?
Everything I have is turned over to the defense. So if they're in existence, I'll have to ask the sheriff if they have them, if they preserved them.
All right. And then also you believe that there's video inside the jail itself where some of this took place, Mr. Pate?
Well, I have video from inside of the jail. I think it's all after Mr. Walker's arrest, but what it's alleged that he went up to the courthouse door, they wouldn't let him in, and then he got upset and went over to, I keep calling it the sheriff's annex, but it's wherever the dispatcher is. And then he allegedly was yelling at the dispatcher from inside that building. I'm not as familiar with that building, but I would presume there would be video of that. And I guess, I mean, I can think of no more highly relevant evidence really for the state or the defense than video of what are probably the acts that they're charging Mr. Walker with.
I would agree, Mr. Pate. Should that interior video exist, the court will require that to be turned over to the defense, as well as the video from outside the courthouse building. I'm going to require the prosecutor to inquire of the sheriff's office as to the existence of those videos and with any audio track that would go along with those. That needs to be turned over to the defense no later than Friday, November the 1st. Obviously, if you can turn it over sooner, Ms. Gillette, I'd ask you to do so to allow the defense time to prepare.
Judge, we'd ask for the ongoing gag order to not be turning it over to media outlets from the defense.
I'm not going to turn over anything to anybody other than
we'll extend that order to both the bill of particulars and to the videos which are produced. They're not to be turned over to any person, Mr. Pate, without the express advance permission of this court. And I appreciate your statement, Mr. Pate. I have no doubt you intend to follow through with it. All right. Mr. Pate, I think I've entered a ruling as to both aspects of your motion currently before the court, but is there anything else that you believe we still need to explore?
There is, Your Honor, and I think this might have been addressed by a motion that Mr. House filed. The amended complaint information of August 15th, 2023, and I'm focusing on count 3 only. In that amended information, Mr. Walker is charged with Class A misdemeanor battery on law enforcement officer against Deputy Amy Bliss. And then in the second amended information filed November 13th, again of 2023, count 3 is charged as battery on a law enforcement officer, but is now stated as a severity level 5 person felony. The second amended complaint was filed after the preliminary hearing. I reviewed the preliminary hearing. I didn't see anywhere in there where Judge Lee bound Mr. Walker over on a felony for count 3. So I guess I'm asking for some clarification as to what's going on with count 3.
Well, the most recent charging document controls, and it's now charged as a level 5 felony, is it not?
Well, it is, but Mr. Walker was not bound over for trial on a level 5 felony on count 3.
But wasn't he bound over on a felony?
He was bound over on aggravated battery on a law enforcement officer as a felony.
Well, Mr. Pate, what authority are you citing for the proposition that he has to be bound over on all felonies? Isn't the purpose of a preliminary hearing to determine that if a felony crime has been committed and that the defendant committed it? And once he's bound over on a felony, doesn't the state have the latitude to charge additional felonies? And if not, what authority are you citing?
Well, he's never had a preliminary hearing. Well, and let me back up. Count 3 is as to Deputy Bliss. Count 4 is as to Deputy Watts.
Okay, okay. But why is that a difference that makes the difference? Once he's bound over on a felony, probable cause has been found to bind him over for trial. What authority are you citing that he has a right to a preliminary hearing as to each and every count? I don't believe he does, Mr. Pate.
Well, I don't think
I think the state has latitude to add additional felonies once there's been a bind over. And if you're citing some authority to the contrary, please place that before the court at this time, and I'll consider it.
Well,
Mr. Gillette, do you disagree with the court's analysis here?
Deputy Bliss was working as in the corrections version of
Okay, I don't want to know about that.
jail.
I'm asking you whether you should be providing a second preliminary hearing on an additional count.
I thought it was included in the original one, but I'll need to go back over the transcript.
Okay, well, I think there's a legal principle here that we just need to sort out. Again, Mr. Pate, do you have any authority, statutory, case law, or otherwise, that a defendant has a right to have a preliminary hearing on each and every count of the information?
I don't have a motion in front of the court, but he's got a statutory right to a preliminary hearing, and the court has to make probable cause findings.
But the court did. The court did. The court bound him over on a felony already. Isn't that true, Mr. Pate? He was bound over on a felony. She's just added an additional felony count, hasn't she? And why isn't she entitled to do that?
Then I would presume he'd be entitled to a probable cause finding on that. And
well, I don't know what proposition you're citing. And again, if you have authority for that, please cite it.
And my client
and I don't. Are you saying that there's a motion on file that was unresolved at some point?
Well, I was thinking maybe there was. My client just passed me a note telling me that he thinks that was addressed at a previous hearing with you, Your Honor, where it was ordered that charge be reduced back to a misdemeanor. I don't have a date or a transcript. But as to count 3, that it was ordered to be reduced back to a misdemeanor.
I don't recall that ruling. And I would have thought that would have been journalized by the defense if there was a successful granting of their motion. And I don't think that's part of the file.
No, it is not in the court file.
Okay. And I appreciate your thorough examination of that file. There's a lot in there at this point, Mr. Pate, as you know. All right. Again, this was not scheduled for hearing today, Mr. Pate. I certainly don't want to see the state compromised because you've raised an additional issue that wasn't noticed up. But I guess I'm just interested in whatever authority that you're citing for that proposition. It ought to be a simple statutory or case law cite.
I would agree, Your Honor, and I'll file an additional motion if necessary.
Quite frankly, Mr. Pate, it's been this court's experience as a practicing attorney that some prosecutors routinely add additional charges if they're required to put on evidence at a preliminary hearing, that they add additional charges following the preliminary hearing. It's a prosecutorial tactic that I have seen. And
Yeah.
it doesn't trigger the requirement for additional preliminary hearings every time a charge is amended, or additional felonies added. But again, if there's authority where a court has disapproved that practice, I'd certainly be willing to consider it.
But I think the distinction I'm making here, and that's been my practice as well, that felonies routinely get added. But my experience has also been after the evidence is presented, the prosecutor will ask the court to bind over on additional felonies, and then the court makes the specific finding that probable cause was found for those additional felonies at the preliminary hearing. But I guess that's the point I'm trying to make, is the Judge Lee did not make any felony probable cause findings other than count 4.
And again, I don't understand why that would be a difference that makes a difference. He's been bound over on a felony. He's set for a felony jury trial. I mean, he's been arraigned on a felony. The fact that an additional felony was added, I don't see what difference that makes. How is he materially compromised by it?
Well, and
He's going to go to trial on a felony regardless. But
he is.
Again, authority is really what I'm asking for here, Mr. Payton. If you don't have any to cite, I think we're just having an academic discussion at this point.
Like I said, Judge, I will file an additional motion if necessary.
All right. Citing whatever authority you're relying upon.
Yes.
And this court will consider it. Again, having not been the preliminary hearing judge, I don't know exactly what evidence was presented or what findings were made. So without a transcript before me, I wouldn't be able to determine that. And do you have your preliminary hearing transcript at this point, Mr. Payton?
I do, and I've reviewed it.
Okay.
And he was
All right.
only bound over on the one felony.
All right. Again, I think a separate motion is called for here. I can probably, if you cite appropriate authority, I might be able to decide it without oral argument. But I want you to put that on file with whatever authorities you're relying upon.
Yes, Your Honor.
And then I think I want to give Ms. Gillette obviously some opportunity to have at least seen it and respond. So if you can get that on file promptly, Mr. Pate, we're running short on time. All right, if there's any further issue to be decided, a hearing will be set at that time and will be decided at that time, Mr. Pate. So I'm going to require you to have any motion that you've contemplated filing here this morning on file by no later than Monday, October the 28th.
2 weeks later.
This is in the District Court of Elk County, Kansas, case entitled State of Kansas versus Robert Walker Jr. This matter comes before the court at this time for pretrial conference. Implicitly, the court's also going to need to decide at least 2 motions that have been filed by the defense. And counsel, I just became aware during this recess I took to join on another device that apparently there's been a new filing in the case of what appears to be a 3rd amended complaint and information, though it is not labeled as such. I have it printed out. I don't know if I understand totally what the implications are of the amendments, but we will proceed further at this time. Regarding the first motion that the court is going to take up this morning, and that is the motion to dismiss or amend. Mr. Pate, if you just summarize for the record here, what are you seeking by this motion?
Well, Your Honor, the 3rd amended complaint filed this morning at 9:31 resolves my motion to dismiss. That the request was that count 3 be properly amended back to a misdemeanor battery on law enforcement. This amended complaint accomplishes that, so this motion is moved.
Well, Mr. Pate, I do not totally agree. Count 3, and the state has had multiple opportunities to clarify this point. Count 3, in the view of the court, does not properly charge battery on a law enforcement officer. It charges battery. There's no allegation in the text of count 3 that identifies that this was a battery on a law enforcement officer. It uses the name of Deputy Annie Bliss, but the reality is the law enforcement officer is an element of this offense. That element is not charged in this particular document. And quite frankly, the amendment, if any, should be to a Class B battery, just based on the language of the charge. Do you disagree with that, Mr. Pate?
Well, Your Honor, actually, I think that is a proper analysis, and the focus of my motion was inexplicably between the first amended and the second amended complaint information. It was elevated from a misdemeanor battery law enforcement to a felony battery law enforcement. And that was the focus of the motion. But I do agree upon further review, the court is correct. It does not have the additional element of law enforcement in the actual text of the complaint. It has it in the title of the charge, but not in the text.
All right. Despite your earlier pronouncement, Mr. Pate, the court's inclined to grant the motion to amend count 3 to reflect a charge of Class B misdemeanor battery based on the language of the charging document. And again, the state has had numerous opportunities to either enhance or clarify the language of their various charging documents. The court will have this case go to trial on what's actually being charged. And again, it'll be the court's ruling that count 3 will go to the jury as Class B misdemeanor battery. All right. Regarding your other motion to dismiss, Mr. Pate, again, summarize your position in regards to that motion.
Your Honor, we were last before the court on October 14th. At that time, I filed a motion for bill of particulars. The court granted my motion. The court ordered the state to file a bill of particulars 7 days from the date of that hearing, which would have been October 21st. No such bill of particulars was filed. So I just simply filed a motion to dismiss count 1 in line with the court's previous order. I don't even think I needed to file the motion necessarily because the court already made the order. However, I did, so the record was clear. It did come to my attention this morning, or actually last night at 6:53, it appears Ms. Gillette did file the bill of particulars. However, I'm asking the court to stick to its previous order, which was that needed to be filed by October 21st or the count gets dismissed. There was no request for extension of the deadline. I'm just asking the court to enforce its previous order and dismiss count 1.
Ms. Gillette, even if this court were to construe the 7 days that the court set forth in this case as 7 business days, you're significantly out of time. I note that you did file a bill of particulars, not just as to count 1, which was consistent with the court's order, but apparently in regards to all other charges of the information. So what is your response to Mr. Pate's motion to dismiss?
With all due respect to the court, I had a jury trial last week because I had jury trial set 2 weeks apart by the court on the master calendar. Therefore, I was in jury trial prep, and doing jury trial all last week. So I took time to sit down and do all the bill of particulars stuff, get it ready, and have it filed for today. The way the court's calendars have been for me, I had jury trials back to back, and I've had jury trials 2 weeks apart more than once this year. So I got everything done as soon as I could, as soon as the jury trial was over, because I had other stuff that was also pressing that comes in while I'm in jury trial, such as child in need of care information, which has to be done in a very specific time limit as well. And seeing as how neither of my counties can afford to have extra assistants that can do all of this extra work, I do it myself.
All right, 2 points come to mind. First of all, you're only required to do a bill of particulars in regards to count 1, not all counts. So I think that would have restricted the amount of time necessary to respond. And number two, wouldn't the proper procedure have been for you or your office to file a motion for extension of time prior to the expiration of the deadline, so that at least that was on file to request the court to extend the time that the court had originally allowed?
Judge Young, I understood that you wanted a bill of particulars for the entire complaint, and that's what I prepared, was the entire bill of particulars for every charge.
All right, well, that's inconsistent with the court's notes stemming from that hearing. I think the issue was, and the controversy was around the disorderly conduct charge in count one only. I don't recall that Mr. Pate had asked for a bill of particulars as to all counts, but really clarification as to count one. Quite frankly, I understand, Ms. Gillette, your busy calendar and considerable workload that you have, but the court's inclined to enforce its deadlines. The court, in this case, allowed 7 days, and even, again, construed liberally to be 7 business days. You're out of time. And the court, this close to trial, is not inclined to grant the state an unrequested extension. And so the court will enforce its earlier deadline order in the case and will dismiss count one of the information, which is, I think, even under the most recently filed one. Yes, is count one, disorderly conduct, the Class C person misdemeanor charged in that particular count. Furthermore, especially in light of the court's ruling in regards to what is currently count three, court is going to direct the county attorney's office to file, and I think it needs to be specifically designated as Fourth Amendment complaint information, which shows the court's ruling in regards to what is now count three. And because the court has essentially eliminated through dismissal count one, Ms. Gillette, it would seem to the court that it would be useful that the Fourth Amendment complaint simply have 3 counts, 1, 2, and 3, to avoid perhaps juror confusion as to what happened to a missing count 1. I don't see that in any way that the defendant's compromised by a new charging document that simply lists 1 as presumably what is now count 2, interference with law enforcement, survives the Class A non-person misdemeanor involving Deputy Amy Bliss. Surviving would be count 3, battery, a Class B misdemeanor in regards to Amy Bliss. And then count 3, if that's how you elect to number them and list them, would be aggravated battery on a law enforcement officer charged in this document as a level 4 person felony in regards to Deputy Watts. Again, I just think that it would avoid juror confusion and a possible question in the future. Furthermore, the court has some additional directions that it wishes to make to counsel in this case.
Judge, the way Odyssey works, they don't do it that way. So I'll have to amend every count to something different, and it'll all have to be changed in the Odyssey computers. Because the way Odyssey works, you don't do that. You just have to write that count's dismissed.
Yeah, our case management system is what it is. Ms. Gillette, I have no reason to disbelieve it. Again, I was trying to take a practical approach, but if that's inconsistent with the digital case management system, then I think you need to file the amended document consistent with that system. And I regret that the system's not more flexible in that regard.
Yeah, there's a whole ton of things we can't even charge. And I've had lots of arguments with OJO, and so have all the other prosecutors, that we can't file specific statutes because they're not in the system. You just have to find what's best or closest, and they don't have a miscellaneous to let us fill in what one is.
All right. Mr. Pate, do you dispute that that's how the system works?
I'd probably have to ask my legal assistant, Your Honor, but
Okay.
I don't have any reason to doubt that.
Nor do I. So do what you need to do, Ms. Gillette. We'll deal with it when it comes up. But with that said, the court's going to direct that the state's witnesses may refer, if necessary, to the fact that Mr. Walker's original arrest may have been based. He was arrested for disorderly conduct, though, again, it's not going to reflect that he was charged. But neither party is to refer to the reasons for the dismissal. or that the disorderly conduct charge was ever dismissed. Perhaps because we're going to be dealing with counts 2, 3, and 4, maybe the jury will naturally infer that count 1 was a disorderly conduct charge that was dismissed. I see no useful purpose to either side getting into or arguing regarding the disorderly conduct count. But I hope it's clear that there probably needs to be some explanation to the jury as to why there was an arrest in the first place, which I think led to everything that followed. And obviously, since that arrest apparently was based on suspicion of disorderly conduct, it seems only fair that the state and the state's witnesses may refer to that. But I don't want some explanation or commentary as to the reasons for the dismissal or that even the count was dismissed. Any clarification needed about that, Mr. Pate?
Well, Your Honor, that does bring up another question that I can address by a motion in limine if necessary. Other than the fact Mr. Walker was arrested for disorderly conduct, which I think certainly is a relevant fact because we have to discuss why he was under arrest if we're going to deal with the battery and the interference charges, I think it renders his actual alleged conduct before the arrest irrelevant. And I guess what I'm saying is I don't think the state should then be allowed to go in detail every single thing that happened before Deputy Bliss arrived, because it's simply not relevant to whether he committed an interference with law enforcement or a battery on either Deputy Bliss or Deputy Watts. It only serves to prejudice him in front of the jury.
I see your point, Mr. Pate. Your response, Ms. Gillette?
Judge, we can play because everything from the time that Deputy Bliss has contact with him on is on video. So we're basically going to play those videos. And if you don't have to bring in all the other extra witnesses, that'll make the trial much shorter.
Okay.
So.
Essentially, I think where the trial is going to pick up is what happened at the jail. Would you agree, Ms. Gillette?
He resists being handcuffed or going over to the jail beforehand as well. There's body camera from the moment Bliss arrives at the courthouse. So it'll be from the moment that there's interaction with Bliss and him, or Mr. Pate and I can get together and look over the video and determine the exact spot where we start. And then we'll go through everything in the sheriff's office.
All right. Now, if you look at your bill of particulars in regards to count 2, interference with law enforcement, 2 of the 3 clearly took place at the jail, refusing to be booked, refusing to answer booking questions. The only remaining fact would be resisted arrest by yanking away from Deputy Bliss. Where did that happen at?
Once outside the courthouse and once in the jail.
Having reviewed the video, Mr. Pate, do you agree?
I'll have to review it again. I think probably. I think I'm not agreeing he did that.
No.
But I think there might be something she could argue at that point. So I think we could probably figure that out.
All right. Well, to me, that's where the video is going to pick up. It's going to pick up at the first allegation by the state that he somehow interfered with law enforcement, and appears to be limited to yanking away from Deputy Bliss, because even the state's own recitation of the facts seems to suggest that's what they're alleging, not any other conduct at the door. And I don't know if that happened during the transport to the jail or still at the courthouse door. I'm a little concerned exactly what yanking away means. I mean, what movement is considered actually resisting law enforcement? I suppose maybe it's obvious from the video. But I do hope counsel can resolve that issue and start the video at an appropriate juncture. Mr. Pate, I appreciate your confidence that you can do that. I also am going to set a deadline regarding the filing of the amended information in this case. Again, Ms. Gillette, I know you're busy. I just need to make sure that that's on file prior to our trial date. I'm going to set a deadline for noon on November 5.
Well, and I think we have potentially another issue, Your Honor. In the second amended complaint, which was filed immediately after the preliminary hearing on November 13th, Mr. Walker was charged with aggravated battery on law enforcement level 5 person felony, which is what I believe Judge Lee bound him over on. The bill of particulars, which was filed this morning, now has that count as a severity level 4. And I just now caught that.
Is that consistent with the most recently filed charging document, which again was just filed this morning?
In the one filed this morning, it's a level 4. In the one we've been operating under from the conclusion of the preliminary hearing on, it was a level 5. And as I look at that closer, it has the same issue as count 3 does. There's no allegation in the body of the text of Deputy Watts being a properly uniformed or identified law enforcement officer.
Well, you make an interesting point here, Mr. Pate. I'm looking at the most recently filed charging document in count 4. While charged as a level 4 person felony, again, there's no reference in the text that this was a battery against or an aggravated battery against a law enforcement officer. Ms. Gillette, I think he's right.
It identifies both of them as deputies.
Yeah, but Mr. Gillette, it's an essential element of the offense. We're just supposed to glean by the word deputy that's not part of their name. I mean, who knows? In today's world, people name their children anything. You just list that individual as Deputy Eric Watts. Are you saying that in and of itself constitutes a declaration that this was a law enforcement officer?
It does when it's described as aggravated battery on a law enforcement officer. If it was a KHP officer, it would say trooper. If it was a game warden for the Kansas Department of Parks and Wildlife, it would say game warden. If it's a correctional officer, it would say corrections officer. I think that the law specifically says, and I want this on the record for appeal, that the complaint should be liberally construed to allow grammatical errors or intent.
How many attempts should your office be allowed to get this right, Ms. Gillette? Should this court reward sloppy work from the prosecutor's office? I mean, you filed multiple amended informations here. Scrutiny of a charge should be made by the prosecuting officer in this case and their staff to make sure that the charge reflects the severity level of the crime that you're intending to charge, with sufficient recitation of facts within the complaint to make it clear exactly what conduct that you're charging.
I believe it's clear that they are law enforcement officers, and this is being charged as battery on a law enforcement officer.
The court has before it the pattern instruction setting forth the elements of an offense of aggravated battery against a law enforcement officer or court official. I will state, and I think in support of the court's continuing position, that number 2 requires that the state prove, and therefore, in the view of the court, originally charge, that an individual was a uniformed or properly identified county law enforcement officer. The charging document does not set forth that language. And that it's not just some reasonable inference that could be drawn by use of the term deputy. I think that the state has to actually charge that this was a uniformed county officer or whatever department the person was with. That wasn't done in this case. Therefore, Mr. Pate's oral motion for essentially amendment and or dismissal of count 4 will be granted by this court? Because again, the state has had multiple opportunities to clarify this point and bring that charge within the proper confines of the statute in this case. And the court will grant the motion and show that the count 4 is to be amended simply to a count of aggravated battery, which begs the question, how will that affect severity level given the current language of the charge that Eric Watts essentially was subjected to an aggravated battery, but not as a law enforcement officer, but merely as an individual, given the language of the charge, which was physical contact when done in a rude, insulting, or angry manner, causing great bodily harm or disfigurement. Ms. Gillette, you've handled a number of these cases. Do you know right offhand how that would affect severity level?
And Your Honor, I don't want to muddy the waters anymore, but I'm afraid I'm going to.
Continue to muddy, Mr. Pate.
During the recess, I went and pulled the battery statute and also the preliminary hearing transcript that the court allowed me to have when I was appointed. Judge Lee bound Mr. Walker over on KSA 215413, B like boy, 2, B like boy, and then classified that as a severity level 5 person felony. I then went and pulled the battery statute 215413 B2B. Appears to me to be recklessly causing bodily harm to another person with a deadly weapon or in any manner whereby great bodily harm, disfigurement, or death can be inflicted. And then I went to the penalty section for that, which is in H1 or H2, I'm sorry, H2D like David says that subsection B2B is a severity level 8 person felony. So it appears that the subsection Judge Lee bound Mr. Walker over on does not comport with the severity level that Judge Lee stated on the record. They're two different things. But on the record, he bound him over under B2B, which is recklessly causing bodily harm in a manner where great bodily harm could be inflicted.
Could be inflicted rather than actually caused.
Yes, it's either the alternative means are recklessly causing any type of bodily harm with a deadly weapon or causing bodily harm in any manner where great bodily harm could be inflicted.
Well, I don't think he got into the detail that you did. I think you're just interpreting the language of the statute here, Mr. Pate. He did say recklessly caused great bodily harm.
Because B2B for a normal person is different than B2B for a law enforcement officer, and a law enforcement officer is a level 5.
Well, right now, I'm not dealing with the law enforcement officer question, but rather what type of aggravated battery did he bind over on? If you look at the language on page 46, Mr. Pate, there's probable cause that he recklessly caused great bodily harm. That is consistent with the language that Ms. Gillette has used in her most recent charge in count 4. In other words, she's alleging that it was actually caused here, not just done in a manner where it could be caused. I think her position is it was actually caused. Am I correct, Ms. Gillette?
I agree with that.
All right.
I don't think he says capital B. I think he said B2. I think he had B2A down as actually causing the bodily harm, and that is a 4. B5 is a 5, but he found it was a 5.
But for a non-law enforcement officer, it's an 8, correct, Mr. Pate, looking at the penalty section?
If the great bodily harm does not actually occur, yes, Judge.
Okay, and if it did actually occur as alleged by the state?
I think that's a 5 if it actually occurred.
It's a
Well,
5.
That was consistent with the finding, probable cause finding made by Judge Lee, and it's also consistent with the charging document, which has been filed by the state, that there was an actual recklessly causing of great bodily harm. So you're conceding, Mr. Pate, that would be a level 5?
With the actual great bodily harm, yes, I would agree that would be a level 5. So I think Judge Lee found that probable cause for that factual basis, but the wrong part of the statute may have been cited into the record.
All right. Well, again, the court's going to make its rulings based on the actual factual findings rather than the legal interpretation of those findings made by the magistrate court. And
Magistrate court also found that Deputy Bliss's was a Class A law enforcement misdemeanor. Well, I don't know if he made it.
but he need not make any findings regarding misdemeanors.
Yeah.
The purpose of a preliminary hearing is to determine probable cause for felonies, not misdemeanors.
And there's only one felony here, Your Honor.
All right. Well, what is now count 4 essentially is going to be treated by this court as a severity level 5 person felony charge involving recklessly causing physical contact with another person when done in a rude, insulting, or angry manner, causing great bodily harm or disfigurement. I don't know if there's really a disfigurement claim here, but great bodily harm to Eric Watts. Quite frankly, given the court's ruling in the 4th amended complaint information, that's how it should read, with proper citations to the appropriate part of the aggravated battery statute and the penalty section. Further, I want to reiterate at this pretrial conference that it's still the intention of the court to limit during voir dire the jury questioning portion to only courtroom participants will be allowed in the courtroom physically. There will be no exceptions. If you're not a specifically authorized court official, you will not be in there unless you're a prospective juror, prospective jurors only. To the extent to accommodate the public, I think there'll be a YouTube broadcast that will be accommodated locally. It's the intention of court staff to set up a room or a facility either at or very near the courthouse to allow the public to view those proceedings. So there will not be any spectators during jury questioning. Once a jury is selected and paneled and sworn, then at that point, the court will allow it to just be an open courtroom. As long as there's no disruption by any member of the public, they'll be allowed to fully watch and participate. And Mr. Walker, yes, my prohibition does apply to even your immediate family members. But they can come to the courthouse and they can watch it on YouTube.
A judge requests that there is no recording, live stream, or anything of the jury proceedings. We have had lots of issues with live streaming, everything they can possibly live stream.
Mr. Pate, I am sure that there may be other pretrial issues that we need to discuss. Do you have any?
Just a moment, please, Your Honor.
Sure.
I have one, Your Honor.
Okay, we'll address that in a moment.
I don't think I have anything at the moment, Your Honor.
All right. I think Ms. Gillette identified that she may have an additional issue. Ms. Gillette?
Judge, I'll have personal security with me. It's a deputy from a neighboring county. From the moment that I step on courthouse grounds to the moment that I leave due to the death threats against me due to this case. And I ask permission for that person to be with me in the courthouse, even when I'm in the courtroom. I can't do my job and watch my back, same as you can't do your job and watch your back. And it's just one extra person. They've been sworn in as a special investigator for quite a while, working on a different matter for me, because we hired them to do a bunch of technical media work on a case that we needed someone with that capability for. So I'm asking for permission to have the extra security that my office is having to pay for me.
Is this person currently associated with a law enforcement agency?
Yes, it's a Greenwood County deputy that lives in Elk County. It's Deputy Clinton Hanson, who used to be on the force here.
He will be allowed. And I trust that you're asking this individual even to be seated with you or be present in the courtroom at all times that you are?
I was going to ask for him to be either right behind me in the gallery where he can view the entire courtroom, or because there will be a deputy near the front door, and this deputy will follow me basically to and from my office, to and from the courthouse, anywhere I'm at, just because there's been so many death threats received by my office.
Well, I'm sorry to hear that, Ms. Gillette. All right. I think I've clarified the court's position in that regard. Anything else, Ms. Gillette?
Nothing further.
All right. Again, I'll reiterate the deadline for filing of the amended, which will be, I think, the 4th amendment complaint information by noon on Tuesday, November the 5th. And again, if it can be filed sooner, I highly encourage it. All right. Counsel, I'll need you in the building there in Howard, checked in through any security, and be ready. I'll ask that Mr. Walker, Mr. Pate, Ms. Gillette, I'll be there by 8:45 a.m. that morning, that first morning. If there's any other last minute matters that we need to talk about, we'll have the opportunity to do so before our scheduled start time at 9:00 a.m., which I'd like to get started promptly, if at all possible. All right. Thank you all for your time and input to the court this morning. If there's nothing further at this time, the Robert Walker Jr. matter will currently be in recess, and this meeting may be ended for all at this time.